Welcome to the final IHR History of Political Ideas seminar of the year. I'm Wasim Yacoub, one of the conveners, and today we are delighted to welcome as our speaker Professor Monica Brito Vieira from the Department of Politics at the University of York. Professor Vieira trained as a historian of political thought at the University of Cambridge, where she held a research fellowship and continues to hold a visiting fellowship, I think. Before moving to York in 2012, Monica was a research assistant professor at the Institute of Social Sciences at the University of Lisbon. Her chief research interests lie in the history of early modern political thought, contemporary political theory, and intellectual history. And in recent years, she's focused on the philosophy of Thomas Hobbes and the history and theory of political representation. Both these themes were central to Monica's first two monographs, the first laconically titled Representation, co-authored with David Runciman and published in 2008, and the second, The Elements of Representation, Hobbes, Aesthetics, Theatre, Law, and Theology in the Construction of Hobbes's Theory of the State, less laconic, published in 2009. Monica is published widely in journals of in the history of ideas and the history of political thought, but has also written on democracy, rights, and constitutionalism, a set of themes around which she's writing another second co-authored book. Today, however, she's presenting work from another interest of hers in questions of silence and agency in political thought, though, as the title suggests, there will be plenty of Hobbes as well. So before we start, just a note of housekeeping. Monica will speak for about 40 to 45 minutes, or however long you wish, really, Monica. We'll then break for 5 minutes before having time for questions till 6:45. But without further ado, Monica, please go ahead.
So thank you so much for your invitation to speak at the seminar. And I must confess, this is a half-baked paper, and it will be surely controversial because it's not thought through entirely, and because it kind of tries to advance probably claims that it doesn't sustain properly. So we'll see. But I mean, this paper started as something I just drafted in the context of a grant that I had to study silence as a form of political agency, and I wanted to see what Hobbes had to say on the topic of silence. And it was very exploratory. It was just to see what was there. And then I eventually left it in my drawer, and the book that I'm writing on silence as a form of political agency took a different turn. And I thought that I would go back to this paper for today, and one of the reasons is because I want to test against people who know much more about this than I do, some of the arguments I am trying to make here, and to see whether this paper can have an upshot that is of any interest to Hobbes scholars or beyond. So basically the paper explores the notion of freedom as the silence of the law. I mean, in the written paper, which is really a very rough draft, I sometimes say freedom in the silence of the law. Sometimes I say freedom as the silence of the law. Now, I mean, this permutation is not really something that I can equalize, because it's not the same thing to say that is silence in freedoms in the silence of the law or as the silence of the law. But I want to, by saying that it's silent, that is freedom as the silence of the law, is not just in the silence of the law, I want to claim that these freedoms that the silence of the law covers are extremely important. And this is against many readings of Hobbes that treat these freedoms as leftovers, things that are negligible because they are mere leftovers. So that there is a polemical claim there when I say that it's freedom as the silence of the law, rather than simply freedom in the silence of the law. Now, I produced a very minimalist, I suppose, PowerPoint, just to kind of take you through the main arguments quickly, and then to open to the discussion as quick as possible as well. So I'm going to share this with you now, and sorry if it's not the format of that you use normally. I just thought it might be of some might be useful just as a start of conversation. So basically, when I started the paper, I start with a quotation of Hobbes that it's often mentioned but very little discussed in any detail. And the quotation is one that, I'm sorry, it's here in my first slide, so you will know it. It's from chapter 21 of Leviathan, where Hobbes says, as for other liberties, they depend on the silence of the law. In cases where the sovereign has prescribed no rule, there the subject has the liberty to do or forbear according to his own discretion. And therefore such liberty is in some places more and in some less, and in sometimes more and in other times less, according as they that have sovereignty shall think most convenient. Okay, so there are quite a few things that one could say about this passage alone. We see that the silence of the law allows for liberties of subjects, liberties meaning here that subjects are left to act at will, they have discretion as to do or not to do, it, that these liberties are variable across time and space, that they touch upon matters of convenience, not necessity, and of course the sovereign as the EU judges not only necessity and convenience. So all of this comes from this passage alone. Now in other passages, and there are not that many passages where Hobbes refers to this freedom or discusses it, Hobbes says that this is the greatest liberty of subjects, meaning that it covers a wide range of actions, a very wide range of actions, so it's extensive. But I would also say that there is some significance to this freedom. And when he lists the kinds of freedoms that lie in the silence of the law, he refers to the liberty of buying and selling, of entering private contracts, of choosing where to live, what to eat, what trades to practice, how to educate one's children. But taking alone the freedoms of contracting in the private sphere that this freedom covers, we see how important these freedoms are, because private covenants structured civil society. They structure civil society, and that's extremely important. So these freedoms are not in any sense, I think, freedoms leftovers or marginal things. They are quite important for civil society in Hobbes and for the flourishing of commodious living within the Commonwealth. So I think they are more important than they are often taken to be. Now, one thing that also comes across in this passage and other passages, the few that Hobbes dedicates to this freedom, is that there is a very clear polemical thrust to saying that freedoms lie not in the law, but in the silence of the law. And of course, Arrington was very clear to show this when he said, oh, Hobbes makes a huge mistake by taking freedom from the law for freedom in its proper sense. There is only freedom by the law, he claimed. It is law that makes us free, not law's absence. And of course, here we have a Republican understanding of the law as a liberatory, emancipatory agency or agent, rather than freedom residing or lying in the absence of the law. Now, this is clear at various points that Hobbes is targeting the Republican understanding of freedom. So he's saying, okay, so freedom is there in the absence of the law. There is a problem in thinking that freedom lies in the law and law that we make ourselves. It makes no difference whether we make it ourselves. And in republics, there are, Hobbes claims, empirically, normally more laws. And where there are more laws, the space for freedom of the subjects is curtailed. So there is a whole kind of polemical thrust to this claim, which Hobbes makes clear at different points of Leviathan. Now, I want to move to my discussion of how this freedom relates to other understandings of freedom in Hobbes. And here I think is where I start making some claims that might be, in terms of Hobbes' interpretation, controversial, at least to some extent. So I argue in the paper that Hobbes has different understandings of freedom according to their predicates. So there are freedoms that relate to body, or are freedoms relating to body, to man as an animated rational body, or to subjects. And the different predicates, body, man, and subject, imply, in my view, modal shifts in Hobbes' understanding of freedom, or in the type of freedom that applies. Which means that one, in my reading, or what the reading I advance in this paper, it is somewhat, I suppose, misleading to take freedom proper, or freedom as the absence of external impediments to motion, as the kind of a normative or a baseline from which other understandings of freedom are to be derived. And this means that we derive freedoms of non-obligation from the understanding of freedom as absence of impediments or absence of constraints. And I'm trying to argue in the paper that there is really a modal shift as Hobbes goes from one to the other. I also show that this is not entirely clear always, that in De Kive, this is not the case, and Hobbes includes an understanding of impediments as arbitrary impediments of fear of coercion, and therefore he muddles a bit this distinction. And also in Leviathan, there are some passages where it seems that we are in a continuum from freedom as non-interference to freedom as non-obligation. But I am trying to kind of claim that there is more of a divide, and that freedom as the silence of the law falls entirely on freedom as non-obligation, rather than freedom as the absence of impediments, as it's so often taken to be. And that's kind of like where I want to go with this argument. Now, just for a little bit of background to this, to what I'm claiming here, when we take the normative notion of freedom to freedom as the absence of impediments to action, we are relying here on a notion of freedom that is corporeal, meaning that it is the predicate of anything that has body, and this includes non-humans, as you will know, but also that is negative. And it's negative in the sense that it implies the absence of external impediments, and that it is irrespective of constitutive or enabling conditions, such as power to act. Okay, so that's what makes it negative. And it's negative in these two senses. Now, freedom of subjects, for me, in Hobbes, is freedom as non-obligation. And this but there are two types of freedom that one can separate here. One is freedom as non-contractual obligation, and one is freedom as non-legal obligation. And these are very distinct. And I will take you through these in more detail, but this is a polemical kind of claim in the literature, and there's not much that covers freedom as the silence of the law, because freedom as the silence of the law is very often taken to be about remnants of the natural right, which I think it is not. So what I will be claiming is that it is not freedom as non-contractual obligation, it is freedom as non-legislation, as non-legislative obligation. And I try to kind of establish this difference by working out what freedom means for Hobbes, and these model shift between different understandings of freedom. Now, here is where I am getting at with this argument. So when Hobbes speaks of freedom of the subject, he says that there are two types, right? He says that there is true liberty, and then there is freedom as the silence of the law. Now, true liberty is freedom as contractual non-obligation, because it resides in those rights we cannot possibly lay down, because that laying them down would be contrary to the purposes that we are trying to achieve by covenanting and entering the Commonwealth. And so those are the parts of the natural right that remain with us. Whereas freedom in or as the silence of the law is what we call legislative non-obligation, meaning that where there is no law, there is no obligation to do or forbear. And I want to argue that they are quite distinctive. So the true liberty, as I said, is a remnant of the right of nature. And this is one's right as man or a woman. And it's a right, and therefore this freedom is characterized by being enjoyed independently of the sovereign, and even if the sovereign chooses to interfere or legislate, because we still have the right to resist if our self-preservation is at stake. By contrast, freedom as the silence of the law is comprised of those actions that are permitted by the sovereign's legislative omission or abstention. And these, by contrast to the natural freedoms that we retain, cannot be held independently of the sovereign or against his commands, are granted by the sovereign's authority and at the sovereign's pleasure, and arise not from right of nature, but from the contingent fact that the sovereign has not spoken. So I'm trying here to clearly separate and saying that the freedoms that lie in the silence or reside in the silence of the law are not remnants of the right of nature, as some people argue. They are quite different in nature, and they are structured quite differently to the freedoms that are survivals of the natural right and necessary to retain rights to preserve ourselves in being, if necessary, to be exercised against sovereign laws or sovereign actions, such as when it comes to put us in chains and we resist them. Now, I want to take us into a discussion of silence and what does this silence in the silence of the law mean? Now, it's interesting here to see that silence can mean simply, and that's the most obvious meaning, non-pronouncement. When the sovereign doesn't speak, when the sovereign doesn't regulate, doesn't legislate, those spaces remain free for us to act in as we wish, as we want. But it's not only that the silence of the law is produced by non-pronouncement. There are other ways in which the silence can be produced, for instance, by repealing a formal law. If we repeal a formal law, there is an emptiness where that law was, and there is freedom that is built on the silence of the law. And sometimes the silence is described in the law, and there is an example that Hobbes gives about marital law, that if you might regulate marriage, but not specify that people have to have one spouse, and therefore polygamy will be admitted. So silence is within laws that regulate certain things, can also leave spaces in which we can act at will. So there are different possibilities as to how this silence of the law might be constituted. Now, one tricky thing about silence and sovereign silence is that silence can be two very different things: absence of meaning or a meaningful absence. And by meaningful absence, I mean here a sign of the will. Okay. Now, Hobbes touches upon both of these when he speaks of freedom as the silence of the law, because he has two understandings of this silence. One is an argument, there is an argument about impossibility, and it's an argument about a constitutive limit to sovereignty, meaning that you cannot legislate everything, you cannot cover everything, there will be omissions necessarily. And the second argument is an argument from will, meaning that the sovereign might decide not to regulate as an exercise of sovereignty. Now, these are different understandings, because in the first, the argument from impossibility, the silence resulting from associated with this argument might be an absence of meaning, right, an omission. But when it's an argument from will that the sovereign decides not to regulate, then we have a meaningful absence, an intentional action not to speak or not to do. Now, it's very difficult to determine whether it's one or the other, or it can be quite tricky to determine whether it's one or the other. And therefore, I think this has consequences as to how we read what this silence does. I'll get to that in a while. But Hobbes uses a particular verb when he says what the sovereign does when he produces this silence, and he uses the verb pretermit, and the verb pretermit covers a wide range of actions from involuntary to voluntary, because it can mean things like failure to notice or do, overlook, neglect, disregard intentionally, omit, allow, or permit to pass. So the spectrum covers both of these arguments that I have been separating out, and silence as absence of meaning as meaningful absence. So it doesn't sort it out for us. In the paper, I tentatively argue that also because of this difficulty in reading silence, the silence that creates freedoms, and these freedoms that accrue in the absence of the law, the silence associated with this should be read as an implicit negative permission. Now, I say implicit because it's a permission that is inferred from silence. So this silence it works as a sign by inferring. And this is something that Hobbes uses with respect to covenants, that one can covenant by words, but also by silence, and some silences can be read by inference as signs of consent. And I think that this is the implicit nature of this permission comes from the fact that it's read by inference. Now, I say it's a negative permission, and this is because the silence here is not producing. I mean, there is a way. There are laws that there can be law. In Hobbes, law is always obligation. It commands or it forbids. But there can be laws that allow, but Hobbes doesn't have the space for that, and that's why, I mean, whereas the space for permission normally was arbitered under the natural law, it seems that Hobbes has to go for silence rather than the law as the space for permission, because of this. But so I say that it's a negative permission, and this is negative because it doesn't rest on a determinate act of law granting permission, but on the absence of law. Now, I here wanted to note one thing, which is that there are different silences that the sovereign can produce as legislator, and that they are quite different and offer themselves to quite different readings. One is law by silence. So when Hobbes discusses common law, he says that the sovereign's silence can make customary law authoritative. And here, the silence of the sovereign is being read as, I think, as positive authorization of the custom law. Now, this is making law by silence. The silence of the law is quite different because it's not making law. It's not making law that regulates something. It doesn't regulate actions by conferring the authority of law. Rather, it's signaling a willingness to leave things outside the law and open to subject discretion. So it's not, in my reading, positive authorization, but negative permission. What the laws do not prohibit can be permitted. So this kind of reading. Now, I think that this more restrictive reading of silence as not positive authorization, but as negative permission, also goes better with the fact that silence is ambiguous, and that the meaning of silence or the intentions behind the making of silence, if it is a meaningful silence at all, are to be read against conventions, against context, against expectations, as it happens with covenants, where Hobbes says that to read the silence as consent, one needs to read it against the expectations, what one's trying to achieve by covenanting. But as we have seen, not all silence has meaning, and not every silence signals, therefore, a will. And in the silence of the law, Hobbes admits that some of these silences are constitutive limits to sovereignty, meaning that they are not made by the sovereign, they are omissions, necessary omissions of any man or group of men that rules, that cannot cover everything that is every single form of human action. Now, I think that this alone recommends an interpretation or a default interpretation of the silence as permission rather than as positive authorization. Now, another thing that should be said here is that where civil law is silent, the natural law speaks. And I think this is important because I think the natural law offers a validity condition for the default interpretation of the silence of the sovereign as permission. This is because, as Hobbes puts it, it's against natural law to constrain by human law more than is necessary for the good of the Commonwealth. So there is a very strong presumption in Hobbes against over-legislating. And that excessive legislation is if bad for commodious living, for the flourishment of the Commonwealth, for the prosperity, for convenience, but also bad for the system of law itself, because it gets to be confusing, because men cannot be expected to know laws, and they guide themselves much more by natural reason than laws that they know. So the sovereign should be economical when legislating. Now, another interesting aspect of the discussion of liberty as the silence of the law, as in contrast with the true liberty of subjects, is that Hobbes treats the true liberty of subjects, or natural right, or the survivals of natural right, as a kind of blameless liberty, whereas for freedom as the silence of the law is put on the side of innocent liberty. And I try to do a little bit with this. So what makes one blameless and what makes the other innocent? Now, blameless liberty, or the natural right as blameless liberty, I think here blameless is to be read in two senses. First, that natural right stands apart from moral requirements, namely that of respecting the same liberty in others. And also, natural right is not merely something allowed under natural law, but the right thing to do if one's self-preservation is at stake. So it's blameless in these two senses. And natural right belongs to the realm of necessity, that which is necessary for self-preservation. Now, innocent liberty, I mean, I think the innocent implies here that they are harmless. I have some discussion of this in the paper, because I think that actually the liberties under the silence of the law that flourish there are not necessarily so harmless. I think that Hobbes actually tries to take the sting of from some of these liberties, because if you think, for instance, dietary requirements, right, it seems harmless, but if it's in the context of religion, it can be quite controversial and can be the source of conflict. The same with marriage and who you can marry and etc. So all these liberties can be quite dangerous to peace within the Commonwealth. And I think Hobbes is trying to take the sting from them, saying you have to tolerate these things in others. You have to tolerate the differences in ritual, the differences in marriage solutions and etc. But actually they are not as innocent or harmless for the survival of the Commonwealth as the word or the adjective suggests. But the innocent liberties, as in contrast to the blameless ones, they require respect for the same liberty from others. And they also don't imply authorization, but rather suggest indifference, that no harm is caused by pursuing them, that no law has been breached if people explore them. And of course, they locate themselves in the realm of convenience rather than the realm of necessity, the realm of commodious living. And Hobbes does quite a lot of work to allow for grounding these liberties in a way that makes them look innocent. And one of them is the natural turn that is ethics, that is ethics of desire takes, right? For Hobbes, desire is not sinful, and allow for the pursuit of desires, and as men see it, is something that is necessary for our enjoyment of life as such. So he tries to quite ground deeply this understanding that these liberties are harmless, but actually quite important for men, as someone who is moved by desire. Now, I think one important thing about freedom as the silence of the law is that it does not regulate, right? It's not there to regulate, because the permission does not regulate action as such, insofar as it doesn't imply any obligation for the beneficiary of the permission to do or forbear. But though permission does not regulate as such, it serves regulatory purposes, because it entails an implicit obligation, as no one should impede the free exercise of the sovereign permission by others. So it implies horizontal obligation, because if the sovereign doesn't say how many women I should marry or men, then I am not to interfere with others who want to marry two instead of one. So it doesn't regulate, but it implies a regulation of sorts, and it implies that subjects act accordingly. In a way, and the silence of the sovereign must be replicated by the silence of the subjects about these things. If they're speaking or speaking badly about actions that subjects are free to exercise, would lead to strife. And there's an ethics here of a kind of tolerance, obscure tolerance that tries to be implemented through this notion of freedom, a silence of the law. Now, as I said, permission do not come within the notion of law. Law for Hobbes is obligation, but horizontally and with respect to one another, they operate as law. And I think this is quite, I mean, that if I'm correct in this, again, this is quite different from survivals of the right of nature. The structure of the right of nature is completely different to this. And that's something I want to stress by making this point. Sorry, this seems to be, okay. Yeah, this, no. Oh. Sorry, I seem to have got lost here. It's the last thing I want to say. Oh, I have eliminated the last thing I wanted to say from the slides. So what do I want to say with this in the end? And I think this is where, I mean, probably the paper struggles in other dimensions too, but this is where I struggled a bit, but I think I can say some things I do want to say. So when you see people speaking about Hobbes' views of freedom, and people that are quite relevant in the field, and I'm going to use the citation of a philosopher, but I could use the cite historians of political thought as well, Hobbes has been placed in a quite neat juncture. On the one hand, and I'm citing here Philip Pettit, on the one hand, Hobbes has been taken to be one of the earliest critiques and perhaps most significant opponent of the Republican way of thinking about freedom. Okay, and this is something that this paper doesn't argue that much against. But also, and now that's the other side of the coin for Pettit, that Hobbes is taken to be a person who played a critical part in the development of classical liberalism, namely by advancing a conception of freedom as non-interference, or the absence of obstacles or impediments to action. Now, I think with the paper, I kind of ended up the paper being a bit doubtful about the second. And this is because, as I see it, none of Hobbes' liberties of subjects are about non-interference. They are about non-obligation. So the liberties of subjects, both of them, are about non-obligation, not about non-interference in my reading. The true liberty of subjects is compatible with law and with interference, because where the sovereign legislates or interferes by coming after me to put me in prison, I am still at liberty to resist, to use my natural right or what survives of it. Now, similarly, freedom as the silence of the law doesn't seem to me to map out to the negative understanding of freedom in the liberal tradition. And this is because it is not comprised of inalienable rights or natural rights, imposing permanent constraints on what the sovereign can legitimately do. It is not a shelter from power, nor protected against the power's interference. All those freedoms are covenanted away, and the sovereign can choose to legislate. They are under his jurisdiction entirely. It's not meant to, I mean, it's not freedom from the law. If by this is meant that it's freedom outside law's jurisdiction, therefore, it's rather freedom by the sovereign's decision not to speak and contingent on the continuity of this decision. It kind of carves out an area of tolerance that is permitted, structured, and overseen by sovereign power, and can only exist insofar as it is structured and overseen by sovereign power, because the horizontal nature of obligations cannot be kept except for this. So sovereign silence affords citizens liberties that they are able to exercise without others' interference, because those liberties are in principle always subject to the interference of the sovereign. And this doesn't seem to me to map out to the liberal and the negative understanding of freedom. So it's only by being enjoyed at the sovereign's pleasure that these freedoms can be enjoyed equally by subjects. So they have the sovereign kind of presence and or oversight as their condition, or the condition for their existence and functioning. Now, and I want to finish here, the paper doesn't do this well at the moment, but I think there is here a wider or larger possible argument about the importance of silence in Hobbes' construction of the state. And it's very, again, going to Poetic, you know that one of his works is made with words, right? So it seems that Hobbes is an author that you resort to when you want to explore the poetic power of language. Yes, language is problematic, it's disruptive, leads us to disagree on fundamental moral terms, but is also that which, and I cite again Poetic, enables us to establish a commonwealth, binding ourselves to one another by words, where the word of law and morality have a common enforceable sense. And all of this is very important. But is there a place for silence, and is that place of any relevance? And it seems to me that silence, in Leviathan at least, opens up a space for human creativity and self-invention. And this comes through two types of silence. One is the silencing of God. That's a very important premise for our constitution of the Commonwealth. And Hobbes silences God in two ways, because he claims that God does not longer speak to man, but also because he puts God at the limit of representation. God is unthinkable and therefore is unspeakable. And there is no representational meaning when we speak about God. The words that we use about God are words only to honor him, etc., etc. So God is silenced. It becomes of the order, it doesn't speak to us, and it becomes unspeakable in the representational meaning of language. Now, this silencing of God seems to be a precondition for a political world that is self-defining and self-contained in Hobbes. The second part is the silence of the sovereign, and Hobbes is very clear that the silence of the sovereign is important, and this kind of legislative contention of the sovereign to allow for a space of self-development, experimentation, inventiveness, so that men are not only, they contribute to the good of the Commonwealth, to commodious living, but also enjoy their living. Now, it's also important to see that where the law is silent, the natural law speaks, and there is a space for moral self-development. And this is clear in the silence of the law, because natural law gives the validity condition to read the silence as permission, but also in all those sphere of imperfect duties that the law could never command, but are extremely important to maintain a civil society or civility within society. Now, this is all true, and it's also true that all of these, and for all of this to work, for the spaces created by silence to work for the purpose of peace and commodious living rather than its opposite, it still presupposes rule by the sovereign and overseen by the sovereign in a non-legal mode, meaning by processes of education, etc., etc. Now, I think this is all I have to say. I would be quite happy to stop here. I probably said already too much and compromised myself too much with the things I have advanced here, but I'm very happy to be pushed back, and it will take me to think again about the claims I've made, most probably. Thank you so much.
Thank you, Monica. That was a lot for us to think about. So for now, we'll take a 5-minute break to 6 p.m. GMT and reconvene then for discussion. So yeah, get a coffee or a glass of water or whatever. Thank you, Monica. Okay, we're at 6 p.m. exactly. So the floor is open for questions. Just a brief note that we are recording this session. Monica's kindly agreed to that. So if you would like to not be present in the recording, you can turn your camera off and ask your question in the chat box instead. But the floor's open. Who would like to ask the first question? Michael Loven, please go ahead.
Thanks very much. Just turning on the camera and the microphone. Thanks very much. That was very interesting. I thought I'd start off by asking about the idea of permissions that you talked about, of the silence of the law as a permission. And you talked about, I think, quite clearly that Hobbes's idea of law is a command. He doesn't talk about permissions. He doesn't talk about what HLA Hart would call power conferring rules. So the areas of contract or other things are areas of freedom where there's no positive authorization and where you can't talk of law as being, or freedom as being an absence of impediment. And yet, certainly as Bentham says, and as Hobbes himself says, you can't have a valid contract unless you have the sovereign to authorize it. Similarly, the recognition of a marriage, that requires rules that you might get out of inference. Now, at the end, you said that the sovereign kind of oversees it and structures it. But a Benthamic view would say, well, the ultimate point behind it is all some kind of law or coercion. And in fact, you began by talking about the difference between an absence of obligation and an absence of impediments. Again, thinking about Bentham when he talks about paraphrasis, translating concepts into real entities, obligation always comes down to absence of impediment. So I was wondering about that.
Okay. Should I start with?
Oh, yes, sorry, Michael. We'll take questions one by one. So please go ahead and respond.
Just to know the rules. Yeah, no, thank you so much for that. So I have struggled quite a lot whether to portray or characterize this freedom as about permission or positive authorization for the reasons you have said were just put quite clearly before us. And the reason why I adopted negative permission rather than authorization or positive authorization had to do primarily with how wide the spectrum of freedom as the silence of the law is, and how it includes silences that are omissions, non-deliberate, and silences that are deliberate omissions. And therefore it seemed to be quite strong to infer from that positive authorization, or to kind of a universal bracket understanding of positive authorization. Now, because of that, I thought I needed to go for a more constrained understanding of what that silence is doing as permission or negative permission rather than authorization. But you are quite right that in the realm of things that involve contracts, such as marriage, right? Ultimately, you cannot marry anyone if the sovereign doesn't back up that contract, right? And that seems to be a case of positive authorization, and that marriage can take place, and therefore that the terms in which you covenant are okay, and etc. So I kind of my hesitation had to do. So it's true. It's very true that in the few instances where Hobbes speaks about silence and how it might be read, many of them have to do with God and are things that are religious. And he tends to say, oh, it's so easy to say no. It takes so little to say no, that if you say you don't say no, you should take as consent the absence of a no, which stands close to the notion of positive authorization rather than just permission. potentially. And there are instances, at least one in this discussion with Bramall, where he clearly means by this positive authorization. Now, it's not in the context of the silence of the law as such, and therefore I have not thought that we should transpose just because he says that in another context that we should apply the same. Now, I mean, coercion and impediment. So here is the problem with that, which is again something that some people go in your direction, other people might go in my direction. It's very common in the negative understanding of freedom that law is seen as impediment, and it's seen as impediment because of coercive nature of law, and it's coercion or the fear of coercion that actually stops us on our tracks, and therefore the restriction of that comes with the imposition of law is because law counts as an impediment because we fear it. I think that in Hobbes, I'm not sure that you want to continue to subsume freedom as non-obligation because of coercion, and the freedom as absence of constraint, and coercion being here the constraint. And I think in Leviathan in particular, it seems to me that he's doing quite an effort not to subsume one under the other. And this comes through the fact that he's insisting in the Leviathan that freedom as non-obligation is about the will, is about self-binding of the will or the non-self-binding of the will. And if he clearly says that the will or freedom to will is compatible with fear, that fear that comes with coercion. And this is something that changes from the Kivet to the Leviathan. And I think all these steps, to me, signal that he's trying to establish more of a distance between freedom as non-interference and freedom as non-obligation. As I said, it is true that later on, in liberal understandings of negative freedom, it is often the case that they are treated as a continuum, and that the law is treated as a particular kind of impediment, and as pertaining to the same genre of things. I kind of see Hobbes as trying to separate and say, no, it's not an impediment. And now, I know that there are specialists on Hobbes on freedom here, much more so than me, but that's what the effort that he does in Leviathan indicates to me, that he's trying to really differentiate and not treat them as a form of continuum. And he kind of says, ultimately, what binds you to the law is will, is not coercion or the fear of chains. You have to understand that the law works for you, the works for the benefit of the commonwealth. So it's not only relying on coercion, it's binding the will, it's this deliberation or loss of freedom to will otherwise, but it needs to be a willing loss of freedom. So I think the emphasis on coercion is, to me, a little bit overdone in readings of Hobbes. I don't think coercion does the trick and is an insuperable kind of impediment. So that was a bit, but I mean, I'm giving quite a lot, and I'm saying, yes, in the tradition of negative freedom, it is like that. They come to be read as a continuum. I think Hobbes is resisting that, in particular in Leviathan. And the second thing is that the reason why I treat it as permission rather than positive authorization is because I think it's just too much that the silence covers, and too much of omissive silence rather than silence that is a doing on the part of the sovereign to go that strong on it. But there is a problem with certain forms of covenant, I acknowledge.
Angus Gowland, to other people in the queue, if you want to find the raise your hand function, it's under reactions. It's changed slightly, so do that. But Angus, please go ahead.
Yes, so thank you, Monica, for a fascinating paper. I've got one question just to ask you to clarify the issue a bit further that you're just talking about, and then a kind of just a very general comment. The clarification question is really about this differentiation that you're wanting to accomplish between the natural and the civil liberty. And I think you made the case for prizing them apart quite, very clearly and quite persuasively in many ways. What I think though that I still feel a bit puzzled about is why would he want to differentiate in that way, and what does it? I mean, and if he is differentiating these two kinds so strongly, or so in the way that you're suggesting, why does he start chapter 21 by talking about natural liberty in those terms? And wouldn't he have made the differentiation clearer, being Hobbes, if that was what he was really up to? So that's my kind of question about. It's really about what's the force of the differentiation and how to substantiate it. In terms of what's actually in the text. I mean, of course, you are in lots of different ways, but they're right at the beginning of chapter 21. That was the first thing that popped into my mind, really. And then the second comment, just comment about God and the silence of God. I think that's all fascinating. I also wondered about Scripture as the word of God, because God has not been silent in that respect, and what Hobbes says about the divine logos. So yes, God may be silent on many things, but of course it plays into scriptural hermeneutics in quite important ways.
So I think I will start with the second, because I think it's kind of easier to discuss that one. I suppose that you are completely right. God spoke through scripture, but the difference here is between word you can control via monopoly of interpretation, and the speaking of God as something that is happening and you cannot control, and anyone can claim to speak to God or hear from God, and etc. So they are quite different. And of course, the silencing of God in the second sense is a weapon at the hands of the sovereign against those that claim to have authority from God, and etc. Right? So that silence acquires a lot of importance for that. Now, I think there is an effort in Hobbes to push for the non-linguistic speaking of God in a way that is representational, in which language represent or is prepositional, and that is meaningless, right? And it seems that is trying to there take away power from, prevent taking away power from the sovereign by those who could claim that kind of relationship to the sovereign through language, through visual representation, and etc. So there is a difference there that I need to reflect upon, most definitely. But you are completely right. The scripture is there, and scripture plays a role, right? And plays a role depending on how you read it in relation to civil law, morals, or prominent or not. Now, the first point you made, I think. I mean, definitely starts by discussing. So when you meant, just to clarify, when you meant natural, you meant natural right versus the freedom as the silence of the law as as belonging in the civil space. Was that what you meant?
I think I meant, I'll have to remember what I meant. I think I meant natural liberty. Yes, like natural liberty versus my reading of freedom as the silence of laws belonging in the civil realm, right? So that's kind of the contrast you were pointing to. So I think you are quite right that he starts with natural liberty, right? And I think that the reason why he starts with natural liberty is that there is kind of like a concentric thing going on, where natural liberty is about necessity and about the purpose of that the Commonwealth serves, and what you cannot lie down because it would betray the purpose and you could not authorize, right? And then the other liberties are about the realm of or they are depicted as being about the commodious, which is something that is more on the outside and of lesser importance, because yes, it's important for the flourishment of the Commonwealth, but not for peace, security as such. So I think that the order of importance comes through that. Now, I know that it is very common to read what I have placed in the civil realm as yet other remnants of natural freedom, but I don't think
that this is contractual non-obligation because of the rights of self-government that one might lie down. These freedoms could be put down, lay aside, because there's nothing that is essential to self-preservation in them. So they are not contractual non-obligations. Definitely, they are of a different sort, and those are the contractual non-obligations are the things that we cannot lay down, or the parts of natural right essential for self-preservation that we cannot lay down. So I think there is a very important distinction there. Now, why you would have wanted to make such a strong distinction, that, well, in my reading comes across as a very strong distinction. I think I need to think more about that, and I'm not entirely sure, other than this order of priority and this necessity, this necessity versus convenience difference, right? There's a hierarchy to them. But I do think, I mean, what I am pushing is quite a strong understanding of the freedom as the silence of the law, as a freedom that depends on the existence and on the regulation of the sovereign of sorts, right? Whereas the other is not like that. I mean, so, and he calls it true freedom versus the other is not true freedom. And I think that's important, because I think true freedom for Hobbes implies that it's independent of the sovereign. That it's true, it's truly yours. It is there from the beginning yours, it remains yours. Whereas the other, it's at the pleasure of the sovereign. So it's not a true liberty of subjects, meaning that's something that they bring from nature. It's something that is conceded to you. It's something that it's at the sovereign's pleasure. And I think that's important for him to mark that difference, because of how he grounds the covenant and the purposes of the covenant being self-preservation, right? To signal the difference between one and the other. But I think I need to think more about why you would want to make such, if I'm correct, such a strong difference. But I think they have to do with order of priority, and they have to do with how he grounds the Commonwealth and what the Commonwealth is for, and what will authorize the sovereign for. So I think that's quite prominent in the way I'm thinking. However, I also think that though Hobbes' emphasis is all about security and what's necessary to that, I do think that there is there is a genuine concern in Hobbes for commodious living, and that it's obviously very often put as very, very secondary. But I think that your loyalty to the state and willingness to keep the terms of the covenant and to act as authorizers and etc. depends a lot on commodious living, and these freedoms in the silence of the law bring that to the fore, that you really want to make subjects feel that they are prospering, that they are free to do things and experiment things, to be inventive, that they are, and that's part of the strength of a commonwealth. That's part of what makes a commonwealth strong, resilient, and subjects willing to act as authors. And I think that this probably is something that my reading, which probably is not correct, but brings to the fore, that it's not a secondary or afterthought, that effectively feeds into the core of the thing, that it's absolutely essential to keep the Commonwealth in healthy state, and obedience to the sovereign as willing as possible, and with lack of resistance as possible. So I think that this reading brings that to the fore, probably. Thank you.
Quentin.
Thanks very much. And Monica, thank you very much. I found this really fascinating, and especially the material on silence. It's a great example of something it's easy to feel with Hobbes, which is that if you don't get it, you don't hear it again. He hardly ever speaks about silence. And yet you're showing us that, I mean, I doubted the word occurs half a dozen times in the entire text. Yeah. And yet you're showing us it's doing a tremendous amount of work. That's very Hobbesian. I just wanted to ask you about one aspect of your point about differentiation, and this sort of follows up the first of Angus's points, I think. I just had one slight concern about what I heard you say at the start of the paper, which is that we shouldn't think of freedom in the proper sense, as Hobbes calls it, as a baseline to which we have to go back when we're thinking about the freedom of the subject. So that seems to be one way of phrasing your point about differentiation. But when the freedom of the subject is limited by the law, I hardly need to tell you this, that does not in itself take away any freedom in the proper sense of the word. You're always free to disobey the law. And in order to see how this freedom, which is not freedom in the proper sense, but is the freedom of the subject, to see how this works, you have to go back to freedom in the proper sense, because what you've got to see is that the bonds of the law can be made to hold, but not by the difficulty of breaking them. And that looks to me awfully like going back to the baseline, because you then want to say, well, what are you talking about? And he's saying, I'm talking about you've got to be impeded. Either the law has physically got to force you, or the law has got to force you coercively by inducing fear so that you don't act. So that's freedom in the proper sense. And it seems to me there might be a danger of overdoing what I'm thinking of as a differentiation hypothesis.
Thank you so much for those questions. So I think I wanted to say two things. One is a proper answer to, or an attempt to engage with the question, and the other is about your first comment. You are absolutely right that there is very little said on silence, and I mean, if you canvass all the works, there are a few passages that refer silence and that do anything with it. I mean, that actually say anything that you can use. So arguably what I'm doing here is dangerously reconstructive. I have to put a lot, I mean, I'm trying to read a lot and reconstruct a lot without so many I suppose, anchors in textual evidence or lines of argument that are fully pursued by Hobbes. Though I do think that it's doing some work there and it's interesting to explore. But I there's a danger because there is so little there.
But I think that's always true with Hobbes. He never says it again.
Yeah, exactly. But also because it is said in very different contexts and not about the same things. And you cannot assume that they are readily transferable from one context to the other. So all of this, I mean, it's a problem with interpretation in general. But when it's so sparse, it's even more so. So I totally acknowledge, and therefore I wanted to bring the paper because I knew it was a very dangerous terrain and that I was doing loads to fill in the gap. So I acknowledge this. Now, I was resisting, so my resistance to treating the freedom in the proper sense as the baseline had more to do with the fact that when people do that and go in terms of a deductive reasoning to understand freedom as the silence of the law, they normally conclude that it is a remnant of the right of nature, a survival of the right of nature into the Commonwealth, and it's about non-interference. And I think that reading is wrong. So I was trying to disrupt that reading. So that was the main point, though, I mean, I do it in broader terms than that, but that was the polemical force of making that claim, because that reading that goes through that strand of, that strand of reading, I think takes us to the wrong reading of what this freedom is about. So that's my main concern here. Now, what you say is absolutely right. And I wanted to say two things. When you say that, yes, Hobbes says that freedom of the subject is not limited by the law because we can always disobey the law, is absolutely correct. It's also correct that Hobbes will think that actually freedom as non-interference in some ways is more limited in state of nature than in the Commonwealth, because potentially you can be less interfered with in a Commonwealth than in the state of nature, where everyone has a right to everything and everyone can impede you, right? So,
yeah.
So freedom,
that's the paradox, yes.
So that's also, and what you lose there is freedom as non-obligation, because you are obliged more so than non-interference. Though the point you are making is, I think, quite correct, that we are always free to disobey, but something dissuades us from disobeying, right? And that's something you are saying goes back to coercion, which is a form of interference of state and state agents with your action. I totally, this is definitely there in Hobbes, but I suppose that my reading of Hobbes, independently of this paper, is that though coercion is an end point of things in this reading, I think that coercion alone doesn't do it, because you need to, I mean, the encounters we have as a state with the state as citizens and coercive exercise of law are minimal. They can be minimal, and yet we are supposed to abide by the law every day. So I think there is something much or equally strong that needs to be there, which has to do with the formatting of the will, of a willingness of subjects to follow the law, or what they understand to be the law through natural reason, because they see that it's better for them. And of course that needs coercion too, but the Commonwealth should transform or seek to transform the understanding of subjects' relationship with the law, which is obligation, but also something that they see is beneficial. And I think Hobbes has both. I think Hobbes has both. And I just don't want to put an overemphasis on coercion as if coercion would solve the problems, because you have to have the state at your door every day if coercion was needed to do the trick. I think he needs both, and therefore the non-legal means of working on the subject and his will and making people act as subjects and authors of the covenant is really important too. So that's my only resistance to that reading, is that when we take coercion to be the final stop and that freedom to be such a baseline because of that, we might be not giving enough to the transformation of the will and the self-conception of citizens as subjects that needs to go alongside it. So I think that's the point I wanted to make.
Very good. Yeah.
Andrew Fitzmaurice.
Thanks, Wazim. And thank you, Monica. That was really fascinating. And my question is really just something I'm curious about. I was wondering what Hobbes is responding to, what the debates about silence are that are going on at the time that he's responding to. And I mean, you can't possibly, you've already really gestured towards a few, but there's one in particular that I was wondering about. I mean, I was reminded listening to you of James I saying, I think it was to the Earl of Northumberland before he came to the throne, that he could put up with the Catholics as long as they stayed silent. And then, of course, after the gunpowder plot, he introduced the oath of allegiance, or the oath of obedience. And I can't help wondering, which of course meant that he no longer could put up with them just staying silent. And I couldn't help wondering whether Hobbes is in some ways pushing back against both the Catholics on the one hand, kind of saying, Louis qui dit mot consent, you can't just get away with being silent. That's still a form of obedience. So this is, silence cannot be resistance. And so really Hobbes's concern here is about resistance. And on the other hand, saying to James, you don't need an oath of obedience because they have consented already.
So that's incredibly helpful. So let me say a few things. So when I started saying asking myself, what's the relevant context here we're speaking to and why? So the discussions of silence, if we go to Pufendorf, if we go to Grotius, occur in the discussion of natural law and permissive natural law, and as allowing for innocent freedom. So it's always in the context of natural law rather than civil law. And I didn't see any of them using it as the silence of the civil law, which is a shift that Hobbes is deliberately doing. And of course, as I said, law for Hobbes is obligation, and therefore a permissive law is a contradiction in terms. And therefore he cannot say that it doesn't speak of a permissive civil law. It speaks of the silence of that law that allows for permission, in my reading of it, right? So it's kind of like doing something within that debate, I think, because I mean, of course, with Grotius in particular. Now that's a context, right? There's something going on there, and probably I have not really fleshed out what he really is intending to do to that, but there's something there. Now, what you said is really interesting to me, because of course Catholics were very, I mean, at this defense of a dominion of silence as resistance, right? What you could not say without lying, or without, you know, all that.
Yeah. The whole Jesuit kind of defense.
Jesuit debate. And of course, I think you are quite right in saying that when Hobbes says that silence is consent, or is rightly read as consent in certain contexts, and he refers to covenanting and rules by inference, and he says, oh, this can be read from the expectations of the covenant. So if you are a Catholic under a functioning state and you are silent, you are consenting. That can be read from what you want from that state, or for being a subject of the state. Is that it protects you. Insofar as it does, you are consenting. Should you not say anything, it's the same. So I think you are quite right in those terms, that when he discusses signs by inference, is probably targeting that, and right. That's in the context of covenanting. And saying, okay, you cannot just say to one another, I'm resisting through silence, because your silence should be read in this context, should be as consent. So you are consenting. That's the only reading that can be extracted according to expectations. The only intention that can be read from your expectations from the state, living under a working state. So I think that's quite right. However, that's more within the context of the covenant forming the Commonwealth. It's not so much related, I think, or I'm missing something, with these silences that are protected by the silence of, these liberties protected by the silence of the law, where it seems to point towards other concerns that I am not tapping into, I think, because one of the reasons that I think I'm missing sometimes the point is that I'm still not tapping into the right context against which to read this discussion. It is very, for me, it was very surprising to see that, I mean, it seems no one, it's very, this notion of liberties accruing within the silence of the law is actually, from what I have looked into and found, quite a vision. It's quite kind of like one-off in the context, I mean, if you look around to the main authors you would be reading. And so I'm kind of thinking, what, I mean, I'm still puzzled by that. And I'm still missing, I think, some relevant context against which this could be illuminated and actually calibrated. And probably I would understand that my interpretation is going too far or not far enough in certain respects. But I think you are quite right when it comes to covenanting and signs by inference and silence being that the target might be exactly that. But also there is I think the authors of allegiance, right? They are quite important signs of consent, but I think there is in Hobbes an understanding as well that or at least in Levite, the way the covenant is presented, which for me is a fictional thing. It's just like he's telling you what rights and duties you may what rights you need to lay down and duties you may take on to sustain a state which you want. Doesn't depend that much on wording, and I mean, it kind of like if you needed them to spell it out, the state is in trouble in some form. I mean, ideally you don't need it, right? So right. So I think there is something here in this exploration of silence that points towards that. If you need them to spell it out, or particular groups to spell it out, it's because there is a problem. Yeah. So he's trying to push to a reading which is the implicit reading through silence, a tacit reading, which I think should be the one that is the norm.
Right. Okay, thank you.
Thanks.
Adela Haile.
Thanks, Wasim, and thank you, Monica, for a really thought-provoking paper. Well, I guess the thought that it provoked in me might be a little bit silly. It's definitely non-contextual and non-historic, but it might be interesting and fun to entertain it. So I'll go for it since we have time. So I was thinking about your questioning of Hobbes's influence on the development of liberalism and your suggestion that alternatively we should understand freedom in Hobbes as, you put it, freedom by the sovereign's decision not to legislate. So then, completely anachronistically, I was wondering if, you know, Hobbes was here today, do you think, based on this interpretation of his thought, he would then view the history of the modern state as sort of the diminishing silence of the law and sort of the increasing speaking up of the sovereign? And would he have anything to say about that?
I think so. I'm not sure what Hobbes would say, but I will try to say something to what you said. So I think in Hobbes there is a clear inclination to think that over legislation is bad for the prosperity of the Commonwealth, is bad for the system of law. It is confusing. It is you need to note, in a way, I mean, this law is not much, and it's known, and it is interpretable for natural reason, and you learn how to fill out the gaps for natural reason. That's the ideal condition. Otherwise, you get people to not know the law, but also to rely less in their natural reason to fill the gaps, which will always be many. So I think there is a part of moral self-development of the subject that comes with the reliance on natural reason that is in a way supported by few very clear and understandable laws, and any confusion is bad for the system of law and system of justice. I think that's part of what he wants to claim. The other part is about the flourishing of a commonwealth. It's very clear that the flourishing of the subjects is the flourishing of the commonwealth for Hobbes, and that subjects should see that as such, and therefore the commonwealth should provide the conditions under which such flourishing is possible, and subjects should be able to take the opportunity to use them. And I think this is very clear, that this is a space for inventiveness and spontaneity and experimenting things and doing things you want to do, and etc. And that's kind of a positive. And I think that Hobbes really does the work to sustain this, as I said, by reworking the notion of desire and kind of taking desire, developing a naturalistic ethics in which desire is okay, not good, not bad, it's just what it is. We always act out of desires, right? And therefore it's not sinful. And this seems to be a sphere that is carving out for you to pursue desire, right? Things that you want to do, that if they are innocuous, if they, in terms of the sustainability of the Commonwealth, are even beneficial for it, why not? And I think there is quite this reasoning, and this is kind of a liberal kind of mindset, it seems to us, right? It's like what liberals say. But the problem with the liberal argument is that it presupposes that this is apart from the state. This is kind of because the state is not there, because the state, and what Hobbes, I think, is saying, which I think is quite important, is that this exists because the state structures it, because the state allows it, because the state guarantees that the horizontal dimension of these freedoms is maintained, that all the subjects can benefit from it, that apart from that, we would be back in nature. Because if you see, like, a vacuum of the law could be the recipe for us to return to the dynamics of nature, if it was just a continuity. And I think it kind of like, it cannot allow for this space to just be like nature. It needs to be different, and that's why I'm pushing for this understanding of a space structured, permitted, and overseen by the sovereign, and that's what makes it the space it is and allows for things that flourish in it to flourish. So yes, I think there is over legislation very often, and confusing legislation, just as there is confusing just communication. I mean, we live in times of COVID, in which every day we see distinct and different things that make everyone confused and less willing to obey. And I think that's the kind of thing that Hobbes is trying to avoid, that kind of confusion that comes with overdoing it, or doing it without considering enough whether it's necessary or beneficial. And I think that kind of is very much there in the discussion of the space that you should leave to these freedoms. And kind of Hobbes is very this notion of which again goes very well with Quentin's argument about the primacy of freedom as absence of impediment, is this notion that laws are snares, they are traps, they are doing, and they are kind of like you don't really need them if you don't really need them. I mean, and that's very, very clear in treating them as snares. But I also think that there is a very clear polemical thing here, is saying, okay, so you think you have no freedom under an absolute ruler, that's nonsense, because actually republics tend to legislate more, because when we alter the laws, or our representatives do, we think that we can always issue laws and there's no problem, because our best interests will be what the law seeks to promote, and every law will be emancipatory or liberatory. So that it is republics rather than an absolute monarchy that tend to over legislate. So there is this polemical thirst where when you alter the law, you think it's okay to do one more, because the law is something that frees you, and is trying to push back against that, of course, and that's part of the sting in the argument.
Thank you.
So we do have Angus wanting to come in briefly, but I had a brief comment more than a question, but perhaps one, Monica, you'd be interested in responding to, as well as Angus's contribution. So what I found interesting about where your argument sits within this sort of interpretive history of the Hobbes literature is that it reminds me of a sort of polemical take of Hobbes made by German historians of ideas, not just Ferdinand Tönnies, of course, a sociologist, not a historian of ideas, but Meinecker in his Staatsräson book, where he says it's precisely this desire for commodious living that leads Hobbes to construct the state as a kind of carapace that leaves the freedom of subjects and the silence of the laws, specifically to enable this sort of egoistic sort of focus of the bourgeois citizen. And that reading in ways sort of fallen by the wayside, along with that particular tradition of the German history of ideas. So I wondered whether, you see yourself as picking up any strands from that, but reading Hobbes in a more positive light. That's just my sort of brief thought. But Angus, you also have something you wanted to say, which I think will be our last question.
Okay, thank you. So just on this point of over legislating, it just reminded me of Thomas More, of course, going back to Plato. There's a critique of lawyers going on there in the preceding classical and humanistic discourse. And the idea is that too many laws are the sign of a sick state. So the fewer laws, the better.
Yeah.
And I wondered whether that was another angle that could be worked into this. I'm not sure. I don't see exactly how, but I'm sure that when Hobbes wrote that, that was sort of in the back of his mind, if not at the forefront.
Yeah. No, thank you so much. So, Angus, I think you are entirely right, and of course, lawyers could be dangerous for the state, right? If you understood that there was rule by the law, then they could be like the people to appropriate that rule quite naturally, right? So I'm sure that's behind his concerns when he says, and definitely this argument that it's the sign of a sick state, of a confused state that confuses citizens, that is sick, that is not functioning properly, is there, and that line of argument definitely is there, and I should look more into it. Now, Wassine, I think so I'm trying to push back against that reading. So I think that reading, so the problem with Hobbes, right, is sometimes it's co-opted into a liberal tradition, but Hobbes cannot be a liberal, because it all depends on the existence of the sovereign and the possibility of that sovereign intervening. And there are no rights against the sovereign or against the state. And this non-existence of these rights, is a problem, because in the liberal reading of these rights that protect these freedoms, they are against the state. They are, yes, the state stops there because this is my right. And Hobbes doesn't have any such rights. Not even the right of nature is a right against the state. You exercise it against state, but it's not a right you have against the state. So that structure of right is not there, and definitely not in these freedoms. That's what I'm trying to say. It's not things you have against the state. It's things you have because there is a sovereign, and he is willing to give them to you. So this is and he's willing to give them to you, and he's willing to oversee the space so that this gift is not empty, so that effectively others might not stop you from exercising the permissions that he allows you to have. And this is not the traditional, I suppose that a very cavalier reading of negative freedom, which takes away all of these. And I think in this sense, Hobbes is much in a non-historical comment, I think he's much more correct that if you leave it to just a space without state, probably it's a state for the exercise of domination, of overpowering of one's of other subordination, and etc. If the state is not there, it derails into something very close to the state of nature and what is happening there. So I think what I'm trying to push is that it looks very much like that, bourgeois freedoms protected against the states, freedoms from, and I'm trying to say it's not exactly that. Not even the right of nature is that, or the freedoms protected by it, but surely these freedoms are not that. So that's where I'm kind of pushing against that line of continuity from Hobbes.
Okay, well, we're exactly on time then. I think all that's left for us to do in the last seminar of this academic year is to thank Monica for a really fascinating and provocative paper and a bravura set of responses to our long questions. So thank you, Monica.